Greetings to each of you, whether it's morning, the middle of the day, or early evening in your part of the world. A very warm welcome to our guests and attendees joining us globally. My name is Ibrahim Ati, and I have the honor of moderating today's panel, proudly hosted by the Young ITA. Our central theme today revolves around the ethical compliance developments in the MENA region, including the recent amendment law for arbitration in the UAE. This discussion has guests of excellence that I cannot wait to introduce to our audience, which will give precious lessons for both arbitrators and counsels active in the MENA jurisdictions. Let's start with a question first to all the dispute practitioners in the room to engage more thoughts. How many of you are willing to, or have perhaps already assessed arbitrator profiles for appointments? Or maybe who among you is actively considering the entities arbitrators have formally represented before deciding on an appointment? Today's dialogue will peel back layers, bring clarity, and unveil a few surprises along the way. I'm just trying to see if, no, it has not been there yet. Thank you so much, Mr. Rodrigue. So, this compact session, lasting between 15 to 70 minutes, is a journey into the MENA region at a very transformative time, with esteemed practitioners. There is a catch. We will be sharing two key insights that showcase the UAE escalating role as a modern leader in ethics compliance. Indeed, many experts from all around the world are now increasingly engaged with the Gulf modernization of dispute resolution. We will be spotlighting innovative trends, regulatory shifts, and the art of dispute resolution, especially significant now as we globally turn to MENA as a center of expertise. For the audience, understanding the complexities of the Middle East is not just educational. It is critical for avoiding costly missteps in legal proceedings on projects within the region, amplified by initiatives such as the South Division. It's also vital for securing successful relations with clients there. Today, besides strategic insights, we'll also be providing you with essential keys crafted by regional experts to navigate with confidence disputes as it growingly intersects with the Middle East, one of the major references. Before we proceed with the agenda, let me just check if Dr. Hossein... No, not yet. Okay. So, before we proceed with the agenda, allow me as your moderator to share a very brief introduction about myself. My name is Ibrahim Aati. I am a young legal professional trained in civil and common law in the EU and the US. I recently passed the New York bar and I have a strong passion for international arbitration. It's in this dynamic field that I want to play a role with innovative ideas while personally contributing to its future. My role in the ITA, which generally supports this program, is rooted in a desire to bridge diverse legal cultures and foster a deeper understanding within our international legal community for common objectives and challenges, whether in the West or in the East. But today is certainly not about me. It's about the incredible assembly of expertise, intellect, and experience we have on our panel. As we navigate today's dialogue, we aim to achieve two primary objectives: analyze the MENA modernization and explore potential reforms in North Africa and the Gulf. Now, let's turn the spotlight to our panelists. Let's delve into the discussion, starting with the first panelist, Mrs. Balfaqih. Daria, please go to the next slide. Renowned for her presence in the Gulf region, Mrs. Balfaqih stands as the managing and founding partner at Balfaqih Advocates and Legal Consultants in the UAE. Her unwavering dedication to arbitration and sustainability, coupled with her past tenure as director of the Dubai office of the Saudi Center for Commercial Arbitrations, definitely marks her as a leader with vision in the field. The depth of Mrs. Balfaqih experience ensures invaluable enrichment to today's discussion. تشرفنا بحضرتك. This is a great honor to start the discussion with you. Mrs. Balfaqih, my first question is the following. Which pitfalls potential arbitrators and counsels must avoid for successful hearings and post-award review in the UAE, especially in the light of the new amendment law?
Yes, thank you very much for our generous hosts today to welcome us into this webinar. And I'm really excited to share this panel with the esteemed Dr. Ahmed Arfali and Dr. Mahmoud Ibrahim, who, by the way, is here now
Yes.
in the attendees. And I would like to start my discussion or answering the question from reviewing the latest changes and giving a bit of an overview on what happened in the latest changes that have been introduced to the arbitration law within the UAE, and how does it impact the arbitrators, and how it might potentially create some pitfalls if the arbitrators and the parties are not very careful in reading those laws. So the Federal Decree number 15 on 2023 was issued on the 4th of September in 2023. And it introduced some amendments to our Federal Arbitration Federal Law number 6 of 2018. If I can summarize the main changes or the key changes that have happened in this law, it will fall under maybe 3 or 4 main topics. Number one is specifically Article 10, which is one of the key topics which I wanted to discuss first because of the name of my section, which is the requirements on the that the arbitrator should meet at the time of the appointment. So in the previous version of the law, it have mandated that the arbitrator was required to be, of course, a physical person and is not permitted to be a minor, incapacitated, bankrupt, unless they are exonerated, convicted of any felony or misdemeanor, even if exonerated, and a member of the Board of Trustees or the administrative branch of the competent arbitration institution administering the arbitration case in the state, or the ones who have actually appointed in this case. Now, the new law, when it have changed it, it did not omit anything, but rather added another aspect, which is now expressly, it adds further provision to the appointment of an arbitrator, namely that the arbitrator may not have a direct relationship with any of the parties to the arbitration that may prejudice the arbitrator's impartiality and independence. So and I've written a couple of articles, one of them is with Mr. Ibrahim regarding this matter. In my perspective, I see that the article wanted to further emphasize the importance of the governance on the impartiality of the arbitrators. In addition, there was another article, which is Article 10 BIS, which is the conditions to appointing the arbitrator from among members of the supervisory or the regulatory authorities in the competent arbitration institution. This article have caused some level of commotion, so to speak, because of the nature of the market. And it kind of like further emphasized the importance of fine-tuning or like revising or putting under a microscope, so to speak, arbitrators who might be conflicted by virtue of being a member of the appointing authority. So in Article 10.2, the appointment of an arbitrator who is a member of the Board of Directors or the Board of Trustees or the administrative branch of the competent arbitration institution administering the case should not be appointed. However, they have given certain conditions where it might be permitted to appointment. That the respected arbitrator may not act as a chair, so the appointment is only as a co-chair. That the parties shall acknowledge in writing the nature of the arbitrator's connection with the institution and the implementation of the governance system internally within the organization. Now, there are certain things as well within this new amendment that will handle the optimal compliance standard of the arbitration, where it have further enhanced let's say, applicable proceeding within the arbitration law, in addition to the arbitration hearings, where in Article 33, it had been amended to remove the reference to hearings held through modern means of communication, which is now clarified under the Article 28, and also the tribunal's discretion to determine the rules of evidence that should be followed in the event that the applicable laws lacks evidence to rule in the dispute and is now subjected to any alternative agreement. So this allowed us as arbitrator to lean into the IBA rules of evidence or the CIR rules of evidence and so on. So these are, I don't want to go one by one into the articles and enhancements, but this is a snapshot, let's say, of the main changes that have happened within the new amended law.
Okay, thank you so much. Building on that perspective, could you please share with our audience your personal vision for the optimal compliance standards for arbitrators in the UAE and the wider MENA region?
So we cannot deny the importance of the role of the arbitrator and their authority to exercise a proper compliance and proper efficiencies within the proceeding. So for me, from my point of view, it is very important for the arbitrators to fully understand the legal nuances, to fully prepare for the case, read all the submissions as and when they are being submitted to them, really take care of the confidentiality aspects when it comes to running the arbitration, in addition to increasing the transparency and accountability, starting from oneself. In general, we have more and more been accused of having due diligence or due process, paranoia as arbitrators. However, I see that there is a happy medium where we take care of the due process, we take care of the confidentiality, we declare when we need to declare any event that possibly might affect our impartiality. At the same time, ensure that the parties are getting access to justice, because at the end of the day, we're all rendering a service that the core aim for it is giving access to justice to both parties in the most efficient and transparent way possible.
Thank you very much, Mrs. Balfaqih, for those insightful responses. It's evident that the fluctuating dynamics show a great impact on the disputes in the region. Dr. Hussein, could you please accept the invitation as a panelist, which I will send now to you on the Zoom app? Oh, I don't see him anymore. I don't know. Maybe there's an issue. Let's go on. I would like to present our second panelist of excellence, Mr. Ahmed Al-Warfeli. Daria, please go to the next slide. Mr. Ahmed Al-Warfeli is an exceptionally brilliant, dynamic, and certainly one of the most distinguished figures in the international arbitration field in North Africa. After his tenure as a judge in Tunis, Mr. Al-Warfeli achieved the historic distinction of serving as the chief legal advisor to 3 consecutive presidents of the Republic of Tunisia, offering direct legal counsel to the presidency. As a private practitioner, Mr. Al-Warfeli serves as an arbitrator in the entire MENA region, having recently inaugurated the largest Northern African Forum and Association for International Arbitration, Africa Arbitration Forum. It's a very unique privilege to welcome you today, Sil Warfeli, especially as a fellow ambassador representing Tunis Al Khadra. Thank you very much for the opportunity to share in your insights and experiences.
Thank you so much. Nice introduction.
Thanks so much, Zakallah. Sil Warfeli, would you please offer insights on the state of arbitrators' compliance in North Africa?
Okay, first, in North Africa, the situation is the following. We have legislations which are, some of them very recent, like the Libyan law, which is a very new one, which was enacted in 2023. We have laws such as the Moroccan law, which is a little bit new, but we have also the Tunisian law, which was enacted in 1993, the law of Mauritania, which was enacted in 2000, and then the Algerian law, which was enacted, I think, in 2008 or 7. Then you see we have different generations of laws, but in general, we have very general provisions in those laws, which are not as specific as the ones we see now in the UAE. So there are so many topics which are not covered by the law. Second, we are seeing also many new arbitration institutions which are created everywhere, but also with a very general framework, which is vague, ambiguous, and unclear on what are the requirements for an arbitration institution, what does the institution do, what do people or what is the link between the people who are managing the arbitral institution and the arbitrators? Can the director or the owner of the arbitral institution be at the same time appointed as arbitrator? Is it forbidden for him, or what is the situation? There are many ambiguities in the situation, either in the texts or in the practice. And this gives us a certain, let's say, unclear framework. Fortunately, the courts precised some things, at least. First of all, the courts, at least in Tunisia, were very clear that the duty to disclose is a very important and a key duty on the arbitrator, to disclose all the facts that must be known by the parties in order to assess whether they accept such a person as an arbitrator or not. And also the sanction if the disclosure duty is not respected, which is the annulment of the award. We have clear decisions which said that if there is no sufficient disclosure, the award is nullified. And this at least makes it clear that even if before the award things are not so clear, after the award is made, things are now a little bit more clear, which means that the sanction is known. And there are also sub-questions which must be answered, such as, for example, the fact that a party comes after the award is made and says that now I discovered that the arbitrator has some kind of relationship with the adverse party, and now I want the award to be annulled. Then the question, which I didn't see in the court decisions, is to know or to ask this party, when did you know about this relationship and how did you know about it? Because otherwise it becomes a very simple way, a very easy way to have any award set aside for a party who knows that the arbitrator has a certain relationship with the adverse party, but doesn't raise it at the relevant time and waits until the arbitral award is made and then comes to request the annulment of the award. So in general, I would say that the situation in North Africa is characterized by unclear rules and also divergent practices which are not so harmonized. And I can say also that except some institutions, maybe in Africa, in Africa Arbitration Forum, which I am the Secretary General, we can do something to make the rules clear, to emphasize more the ethical aspects. But now most of the arbitral institutions do not do sufficient work in order to promote ethical rules and values among arbitrators, which means that finally every arbitrator is trying individually to set for himself the rules to follow concerning the conflict of interest and ethics of arbitration.
Thank you, Mr. Louafeli. Building on your impressive expertise and experience in the region, we would be very happy if you could share more of your personal vision for the optimal compliance standards for arbitrators in North Africa and perhaps the Gulf as well.
Thank you so much. From my own perspective, there are certain issues that must be covered either by the laws, which means reforms of the arbitration laws, or at least by the arbitral institutions or other institutions which are focused on arbitration. There are certain aspects that to which we must have clear answers. I would state many of the questions which were covered by the new UAE law, such as the situation of people who are at the same time members of the board of directors or any other board in an arbitral institution, and whether they can be appointed as arbitrators by the parties or by the institution itself as presidents or as co-arbitrators. The relationship between the arbitrator and the parties council, because our laws now talk about the challenge of an arbitrator and the duty of disclosure. If the arbitrator has some relationships with the parties, and doesn't say anything when he has a relationship with the council and not with the party itself. So we need a clear answer by the laws, or by at least by the practitioners. And also the meaning of full disclosure, saying that the arbitrator has to disclose any facts that may raise justifiable doubts. What do we mean by any facts or anything that the arbitrator has with the other party? And also to set clear limits between the duty to disclose and the respect and protection of personal data of the parties, of the clients of the arbitrator, and also the professional secrecy. So for me, I expect reforms of the laws in order to be more specific and to answer those kinds of questions, in order to have a better framework, a better environment for arbitration in the future.
Thank you very much, Silver Feli, for those key insights on the MENA jurisdictions, especially on disclosure and the model role that Tunisia is slowly building up in the region. Thank you again.
Thank you.
Thank you. Now I have the pleasure to introduce you to our third and last panelist, Dr. Mahmoud Hussein. Daria, could you please go to the next slide? Dr. Hussein, do you hear us? Could you please activate your audio, perhaps? Dr. Hussein? I think you connected through your phone. I believe so. If so, can you please perhaps reactivate your song or let us know in the chat?
Can you hear me now?
Yes, we
Hello?
can. Thank you so much.
I thank you very much. It's unfortunate today I had a technical problem, and this actually discussion is a very exciting discussion to hear different
So much.
perspectives and different things.
Thank you.
I think one of the things you hear me clearly?
Yes, thanks so much, Dr. Hussein. I was about to present you to the audience.
Oh, yeah, please go ahead then.
Of course. Thank you so much. So, Dr. Mahmoud Hussein, the esteemed Vice President of the ICC UAE and distinguished Chair of the ICC UAE Steering Committee of the Arbitration and ADR, stands as one of the leading figures within the legal and arbitration community across the MENA region, particularly the Gulf and the UAE. As the founder of M&Co Legal, his law firm is renowned for its profound influence and pioneering achievements in the legal framework of the region. Dr. Hussein, important role in the establishment of the DIFC courts, coupled with his recognition as the most promising arbitrator by the Dubai International Arbitration Center, highlights his unparalleled expertise and innovative contributions to the field of arbitration. We are privileged today to welcome Dr. Hussein, one of the very best UAE arbitrators, to share his invaluable insights with us. Dr. Hussein, could you please offer an analysis of the UAE current model for our audience?
Thank you very much. Actually, first of all, apology that I was not had
Thanks so
technical problem, and my IT team tried to fix it, but it didn't work. So I think this time you can see my voice, and I think you hear my voice. So basically, one of first important thing we need to understand that the Middle East region has a rich history, culture, and legal diversity, which presents unique challenge in the field of arbitration, because a small city like Dubai has two legal systems are running together. We have the IFC, which is a common law, and you have Dubai court, which is civil and Sharia court. So those diversity of legal system bring more challenge and different perspective. Now, globally in the field of arbitration, it's ongoing significant challenge. However, when we talk about code of conduct, we always focus about duty of disclosure and duty of arbitrator to disclose and in order to improve the impartiality. However, if we go across and do survey of all of code of conduct, like for example, SIAC or IDA or other guidelines, the focus is disclosure and confidentialities and all of those issues. However, the code of conduct is beyond that, because the code of conduct, and let me give you an example for some of code of conduct which not our legal system, neither the code of conduct governance. The relation between arbitrator by them. For example, I had a case where the co-arbitrator didn't respond to our email for 3 months because he was stretched too much. We had another case where the co-arbitrator, he was very hostile, very aggressive, and refused to submit his descending opinion within the time frame required by it. So basically, it's beyond that. Now, what's happening in MENA region? The MENA region, like other regions, the rise of arbitration, we have many cases. If you look to the statistics show us that 40% or 38% exactly from cases in ICC Paris coming from the MENA, from GCC exactly, MENA region, I would say. So basically, there is a huge number of cases. However, there is no code of conduct. Even in interpretation of the court, interpretation of the local court is very narrow, and does not cover all of the issues that you expect from the conduct of arbitrator, the relation between counsel and arbitrator, the relation between arbitrator himself with the counsel, because we should always think that the arbitrator has a duty to respect the counsels as well. I had one of the cases where I was arbitrator, I was counsel, sorry, and the arbitrator really was really unprofessional at dealing with us as a counsel. There is such code of conduct. So basically, there is no really code of conduct that govern all of those new emerging issues or other issues, because our focus is about disclosure, duty of disclosure. Even in UAE, for example, duty of disclosure, there is a lot of jurisprudence speaking about this duty. So basically, in some arbitral tribunal institution. So basically, let me give you example. Recently we had case in Refined Sugar Association Arbitration Center, and surprisingly, the institution rule didn't oblige the arbitrator to disclose their impartiality and independency. So basically, So basically, there is no such rules in the region to govern this. Thank you very much. This is my highlight, actually.
Thank you so much, Dr. Hossein. We still have like one last question for you. For our US and international audience curious about the Middle East, could you please share your personal vision for optimal compliance standards for arbitrators in the UAE and the wider MENA region as well?
So there is no such thing, because institution focus, as I said, the focus is on disclosure and disclosure only, the duty of the disclosure, but it doesn't go beyond disclosure. It doesn't go with the ethics. It doesn't go how the arbitrators deal with each other. Now, with the jurisprudence of the court is a few. It's not that much developed. Unfortunately, it's not developed that much. And I have seen cases, bizarre cases, where the court said, okay, it's arbitrator is chosen by the party. So basically, if they conducted themselves in a certain manner, is okay. So basically, there is no such thing really in terms of disclosure. Now, it's mostly about independency. For example, they would say if you are in a board of governance of an institution, you cannot take cases and all of that. This is a generic issues. It's not the core issues that we as the arbitrator and counsel face in a day-to-day. Day-to-day, we face a lot of challenge dealing with some arbitrator, and as an arbitrator, you get within the tribunal, you get guerrilla tactic where one arbitrator is not engaged sometimes his attitude is not positive with the co-arbitrator and the chair, and sometimes not collaborative in nature. So basically, all of those issues is not managed in Middle East. So there is a big gap at the region actually regarding this.
Okay. Thank you very much, Dr. Hussein, for highlighting those independency, sometimes generic nuances and issues, and sharing more about the developments in the Middle East. Thank you so much. As our fourth panelist has been physically unable to join us due to health concerns, Dr. Hussein's intervention also marks the end of this panel of excellency. As we have indeed reached the end of our journey through North Africa and the Middle East, I would like to thank again the audience and to extend my gratitude to our panelists. The insights shared today not only shed light on the ethics compliance, but also paved the way for innovative approaches and foreign collaborations with the North Africa and Middle East regions. Thank you for joining us at Excellence in Ethics, Arbitrator Compliance in MENA Arbitration, supported and hosted by the Young ITA. We look forward to continuing these important conversations in the future and, of course, to meeting you in person in a few days, inshallah, for the Riyadh Disputes Week. Thank you once again and take care. شكرا كثيرا على حضراتكم. أنا الأب الفقيه سيلور فيري ودكتور حسين. أراكم على قريب إن شاء الله والسلام عليكم. مع السلامة.